All right. So our next panel, where I'm very excited to have some students visit with you. They've been working very hard this semester on a very difficult topic that we are seeing more and more in the clinic. It relates to people who served in the Gulf. So you guys go ahead and sit down and I'll introduce you. All right, so first is Alec Atkinson. Alec is from St. Louis. He spent time in a personal injury firm, and he's going to go work in a defense personal injury firm. And he is currently in the clinic. We're happy to have him. He's been helping a Vietnam veteran and working very hard on this particular symposium. Next to Alec is Brian Moody. Brian is from Mount Vernon, Missouri, Southwest Missouri. Great guy. And Brian is also in the clinic this semester helping an Iraq veteran and working very hard on the symposium. Next to Brian and Alec is a woman named Amy Odom, and for those of you who have been to the symposium before, she's a treasure. This is a book that we use in our clinic and have always used. It's called the Veterans Benefit Manual. Amy Odom is one of the editors. She's a national expert on these issues. We couldn't have our clinic without her helping us. She helps the students. She answers my questions. She's just a real joy and has been with us since January 2014. So we're very glad that Amy's here. So take it away, guys.
All right, thank you very much for that introduction. So what we're going to be talking about today is a few different areas. First, we're going to start out with some basic context just for your standard disability benefits claim. And then we're going to move into sort of the special rules related to Persian Gulf War veteran claims. And it'll become apparent throughout the presentation why those rules were put in place and how they help those specific veterans as a result. So first, I think it's important first to just talk generally about the VA system. Now, this is a non-adversarial system, which means unlike your standard civil action, your civil claim, both sides aren't trying to discount what the other side is proving, the evidence that they're bringing forth. They're supposed to be working together in order to help the veteran. And sort of a perfect example of that is the fact that the VA has a statutory duty to assist. Now, this begins very early in the process. They have the duty to notify the veteran of any information necessary to complete the claim application. And then throughout the claim, they have the duty to assist the veteran in obtaining evidence or providing a medical examination when necessary. And each one of those duties that the VA is statutorily required to provide will become more apparent throughout the presentation as well, and we'll see how those are necessary in order for the veteran to achieve their benefits claim or prevail in their benefits claim. But the reality of this situation is, despite that this is a non-adversarial system, there's a lot of veterans that are being declined their benefits, not because they're not meeting the necessary requirements, but because there's errors at low levels of the adjudication process. So the Court of Appeals for Veterans Claims, their 2016 annual report said that 77% of cases were reversed or remanded for error. And there's a lengthy process of appeals to get to that court level, but even through that process, they see that 77% of those claims were reversed because somewhere at the lower level, there's an adjudicational error of some sort. So while it's a non-adversarial system, we're still resulting in a lot of veterans not getting the benefits that they so readily deserve. So obviously we're talking about compensation, so what's at stake for these veterans is money. I mean, the money provided to them is supposed to offset the degree to which the disability would impair the average civilian in earning a living. So you go off to service, you're injured, you come back, may not be able to perform the same job duties, or you may be hindered in some way as compared to a normal civilian or compared to how you were before service. And so obviously that money is supposed to offset that and kind of close that gap or fill that gap. And the way that the VA does this is they'll rate your disabilities from 0 to 100% at increments of 10%. Now, if one person is at 10%, this person is at 10%, they're going to receive the same amount of compensation regardless of their occupation. So that's not taken into account, but other factors are taken into account which do affect the level of compensation. So things such as your number of dependents. If you have 3 dependents as opposed to 1 dependent, you're going to receive a higher level of compensation because you're providing for 3 people as opposed to just 1, despite the person with 3 dependents and 1 dependent may have the same rating. So that's just important to note that generally they're at the same level, but there are some factors that will change that. So a lot of you in the audience are probably familiar a little bit with Social Security disability benefits. And I think the most important thing to point out when comparing those two is that for Social Security disability benefits, you have to be totally disabled and that you can't hold down, you can't perform the normal tasks of a job, and as a result, you're entitled to disability. This is not the case for veterans. Veterans, as we said earlier, they are rated, their disability is rated on that 0% to 100%. Excuse me. So if somebody's rated at 10%, they might be able to perform their necessary job functions perfectly fine, but that doesn't mean that they are not entitled to compensation as a result. And somewhere where we see that this is increasingly important is when they're rated at 0%, because even though you're rated at 0% and you're not receiving monetary compensation for the disability, there's still benefits to that. And the benefits are, we'll go through in a little bit the requirements in order to achieve disability benefit compensation. But when you're rated at 0%, despite not receiving compensation, you've already proven all of these requirements already. You've already proven everything necessary in order to receive compensation. The VA is simply saying the level of your disability at this point is not enough to warrant compensation. And in the future, if your disability were to get progressively worse, you would be able to get an increased rating decision and then receive compensation without going through the cumbersome and lengthy process of proving your claim in the first place. And that's something that's very important to point out, because when someone says 0%, it sort of seems like, well, how could there be any benefits to having 0%? But it's the fact that you don't have to prove those necessary requirements yet again. So going on from there, we'll sort of go into the requirements for a standard disability claim, and then when Brian gets more into the details about the Persian Gulf War veteran claim, we'll see how the special rules for Persian Gulf War veterans is incredibly important. But first, we kind of have to lay the foundation in terms of a standard claim. So there's a few prerequisites before we get to the actual elements of a disability benefits claim. And the first is that the individual, the veteran, has to be discharged or released under conditions other than dishonorable. So that's pretty straightforward. You're going to know their discharge status, and you'll be able to move past that prerequisite. The second is the injury was incurred or aggravated in the line of duty. The third, disability is not the result of their own willful misconduct or substance abuse. Now, the first and third are obviously pretty straightforward in that willful misconduct or the fact that the veteran was discharged honorably. However, in the line of duty creates kind of a problem for some individuals, because when you think about it, you think about in the line of duty as being combat related or an injury resulting from a military duty. But all that in the line of duty means is that it's service connected. And that's important because all service connection means is that you incurred an injury during your service time, and that is the point of period of service is your date of entry to your date of discharge. So from the date you go in to the date you come out, if you're injured in some way during that period of time, that injury can be service connected. Now, in terms of combat, not only is this important because it doesn't have to be combat related, but it doesn't even have to be the result of an actual military duty. So I have an example up here. You're at base playing soccer with some other service members. You blow out your knee or something, it causes arthritis in the future, despite you having that injury as a result of playing soccer, it was still incurred during your service, and therefore you necessarily meet that requirement. So that's something important to point out for individuals advocating for these veterans. Now here's where we sort of get into the actual elements to prove the claim and sort of the, kind of just paint a broad picture, broad strokes, generalizing what this claim is going to look like. Won't get into the nitty-gritty details, but first you're going to have a current disability, evidence of an in-service injury or aggravation, and last, competent evidence linking the current disability to the in-service event. Now, for your current disability, this can be competent medical evidence or evidence from an individual with specialized training. So you go to your doctor and he says you have this disability, you have this issue, and there you go, you have your evidence that you do have that current disability. Now, this is when that statutory duty that I was talking about earlier comes into play as well, because this is where the VA, if necessary, needs to provide that veteran with an examination in order to prove that. So that non-adversarial system we're talking about, the VA can actively help the veteran in proving and meeting this requirement. Now, the evidence from an individual with specialized training, I'll talk about that a little bit later when we talk about post-traumatic stress, and that's important because it doesn't necessarily have to be a medical doctor. It could be a psychiatrist, psychologist, social worker who has the specialized training to write an opinion that essentially says that you do have this disability and you're suffering from it, therefore you meet that criteria. Now, for evidence of in-service surgery or in-service injury or aggravation, you can have medical evidence or lay evidence. If you're in service and you get injured and you go seek out necessary treatment while in service, there's going to be records, you're going to have evidence that you did in fact have that specific injury. So that's pretty straightforward. Now, the really important part here is that the veteran can provide their testimony alone, and it can be supported by other service member statements, call them buddy statements, or maybe an article or a book that's written about a very well-known event that everybody is very well known, and as a result, people know that these types of injuries resulted from this specific event. So those things all together can help them prove that they did in fact have evidence of in-service injury or aggravation. Now, another important part to point out is that the VA concentrates on this requirement first. If you don't have the in-service injury or aggravation, then they're going to focus on this, because then when they go to the current disability, they're not going to provide you with a medical examination if they've already proven or it's already been shown that you did not in fact incur an injury or aggravation during service. So that's just something to keep in mind as you advocate that this is where the VA is going to be looking first. Now, the last requirement, competent evidence linking the current disability to the in-service event. This is referred to as the nexus requirement. So essentially you have your in-service event, your current disability. Now you need to connect it to saying this one necessarily caused your current disability. Now, the burden of proof for this is as likely as not, and that compared to the burden of proof in criminal cases of beyond a reasonable doubt, civil cases of preponderance of the evidence is extremely low. So if there's a 50-50 shot that the evidence does support that there's causation between the in-service injury and this current disability, the benefit of the doubt is given to the veteran. And that's very important to point out, because that goes back to this non-adversarial system that we keep talking about, that they've lowered the burden to a point where even if it's 50-50, let's support the veteran and give him the compensation he deserves. So now that we've kind of gone through your basic requirements of the standard disability claim, it's important now to give a little bit of a broad overview of what a Gulf War veteran, their claim might look like. And in comparing the rules that apply to a Gulf War veteran to other veterans, it'll become very apparent why those rules were put in place and why they're so amazing for our veterans to receive compensation. So first, there are special rules that were created, like I just said, And the reason for this is that people coming back from the Persian Gulf have exhibited a wide range of symptoms that were not attributable to any known diagnosis. And as a result, it's difficult to obtain disability compensation under the standard requirements. So if you are looking back at the standard requirements, and we have to prove this in-service injury or aggravation, and a lot of these veterans in this area were exposed to hazardous environments where they don't necessarily have an acute injury where you can point to a specific event and say, yep, that's when I incurred this chronic, he'll get into that later, the chronic disability. But because you can't point to that specific event and you can point to this current range of symptoms, you're not going to be able to connect those in any sort of way. That causation's not going to be there. And as a result, before these rules were put in place, veterans were being denied disability benefits because they couldn't meet the standards of a standard claim. And now these special rules allow it so that if you meet all three of these requirements that I'll go over here in a second, your connection, that nexus requirement, is going to be presumed. So in order to receive disability compensation as a Persian Gulf veteran, first you have to be a Persian Gulf veteran. So it's very straightforward. Second, you have to suffer from a qualifying chronic disability, and that is a very complex area which Brian will talk about in a few seconds. And lastly, the disability has to have manifested during service or to a degree of 10% or more at any time since the veteran's return. So if all three of these requirements are met, the service connection is presumed. Again, you can't point to one instance where this injury was incurred, and as a result, how are you going to have that causation to the current symptoms that they suffer from? So these rules are extremely important as they help these specific veterans receive compensation. Now, this is what I just pointed out, that nexus requirement is gone with this presumption, and that's the most important part of these special rules, is that you don't have to prove that causation. And now I'll turn it over to Brian, and he'll get into a lot more of the details about Gulf War veterans and their claims.
Yeah, so like Alec just pointed out, this is kind of a shortcut for veterans, right? We can skip proving part of the standard disability claim, and instead, we can just prove these requirements, and it will let us presume service connection. So I'm going to talk about, it's a regulatory, standard, the requirements you have to show under the reg to claim the presumption of service connection. It's kind of complicated, but we'll get through it. Okay, first requirement, are you a Persian Gulf War veteran? Second one, do you have objective manifestations of a qualifying chronic disability? Did the disability manifest during a presumptive period? We'll start with the first one. Are you a Persian Gulf War veteran? Okay, so there's kind of two parts to this. Did you serve in Southwest Asia, which includes what we typically think of as the Middle East, Iraq, Kuwait, Saudi Arabia. Does not include Afghanistan, strangely enough. And that comes from a case called Cox versus McDonald, decided last year by a highly esteemed, brilliant attorney who we have with us today.
All right.
She's going to share a little bit about Cox and why that is.
So I was second chair on Cox. Our attorney, Katie Clemens, was lead counsel in Cox. Before we get there, I know this is the second part of your Are You a Persian Gulf War Veteran? But I think usually when you hear the term Persian Gulf War Veteran, you think of the first Gulf War in the early 90s. But in fact, as Brian will explain, the statutory definition of Persian Gulf War, it's still going on today. The starting date is in the 90s, and there is no ending date. So that means that so long as you served in the Southwest Asia Theater of Operations at any time since the early 90s, you're considered a Persian Gulf War veteran for purposes of this presumption of service connection. So it's really important to know what is the Theater of Operations in Southwest Asia. And so the reason why this case even came about is that in 2008, the VA issued what's called a training letter, which is kind of an internal document that they provided, or that the people in the Veterans Benefits Administration, so the policy people, provided to the line adjudicators that said, we interpret the statute, statutory term Southwest Asia Theater of Operations, to include Afghanistan, and a regulatory amendment making this official will be forthcoming. So we somehow got our hands on that first copy of the training letter, and so we thought that that was the actual policy. We were just kind of waiting for the regulation to come out, and it never really came out. So when this case came across our desk, Mr. Cox is a veteran of Afghanistan, of OEF, and he had some manifestations of a qualifying chronic disability, which Brian will get into. And the Board of Veterans' Appeals denied the claim because he was unable to show, one, a current diagnosis for his disability, and two, a medical nexus between his current disability and his service in Afghanistan. But if Afghanistan was in fact Southwest Asia, which this internal document appeared to say, then he wasn't required to meet either of those traditional elements of service connection, because the law would step in to presume that his symptoms were related to whatever he was exposed to in Afghanistan. So we filed a brief when we said, well, the board should have considered this particular, or it should have considered entitlement to presumptive service connection, because according to VA's own interpretation of the statute, he did serve in the Southwest Asia Theater of Operations. Well, lo and behold, General Counsel's office files a brief and says that's not what the training letter says at all, and attaches the very same training letter that we had, same date, same training letter number, everything, with the language about this is how we interpret the statute, to say the complete opposite. Said we interpret this statute to mean Afghanistan is not part of Southwest Asia. And we were like, what? Where did this come from? I mean, we even had it in our Veterans Benefits Manual that there's a training letter out there that says this, so you should argue this. So it turns out that somehow, several months, even maybe a year after they issued the original letter, in the middle of the night, without any indication to anybody that they were doing this, they just changed the letter. Didn't put like any indication on the new letter that it was revised, backdated it to the, thank you, backdated it to the original date of the original letter, kept the same training, it was like training letter number and everything, provided no indication that this had been actually a change in their policy. So we had to get leave from the court to like scrap the whole briefing process and start all over. And this time we came with more sophisticated arguments because we had to. Our first argument was that who here has studied Chevron and loves Chevron the way that I love Chevron? Okay. So our first argument was that there's a plain meaning for the term Southwest Asia as Congress used it in the statute. And we turned to various governmental geographical sources that included Afghanistan and Southwest Asia. Our second argument was, even if we're wrong and there's not a plain meaning, then it's at least ambiguous, and you shouldn't defer to the VA's interpretation because it's arbitrary and capricious. Because if you look at some of the National Academy of Sciences studies that have come out on the direction of Congress to study environmental hazards in Southwest Asia and their effect on people who served in that theater of operations, those studies, first of all, include Afghanistan, and second of all, say that folks who served in Afghanistan were exposed to similar, if not the same, hazards as those who served in Iraq. So we said it was arbitrary and capricious then for VA to exclude Afghanistan from this, its regulatory definition of Southwest Asia, if the whole purpose of the statute and the regulation is to provide a reduced evidentiary standard for showing a nexus between whatever you were exposed to in that area, which we aren't even really clear on what all that was, and what you have now. And then our third argument was that this training letter that we had was actually a substantive rule, and therefore had to go through the Administrative Procedure Act's notice and comment requirements in order for them to rescind it. In other words, when they changed the language in the middle of the night, they were required by law to actually go through the formal rulemaking process set forth by the Administrative Procedure Act, and their failure to do so meant that that change wasn't valid. So the Veterans Court completely disagreed with us on every single point. They said that there is no, well, first of all, not only was there not a plain language meaning of the term Southwest Asia Theater of Operations, but this, the statute was actually promulgated in the 90s, so I think like 97. So the Congress could not have, at that time, intended for Southwest Asia to include Afghanistan, despite our arguments that Congress knew that it was a volatile area and that things could change rapidly. So because there wasn't a plain language meaning, and also because there was a specific and explicit delegation in the statute to the Secretary to define the geographical areas, the court deferred to VA's interpretation of the term, which they said excludes Afghanistan. They didn't really provide any really good reason why it excluded Afghanistan. But remember, under Chevron, they don't have to be right, they just have to be reasonable. And what's interesting too is that in their briefing, the VA said that their authority, okay, never mind, I'm not gonna get into that because Brian's gonna get into it and I'm getting really weedsy. But anyway, it stands to say they rejected that it was arbitrary and capricious. And then they also said that the original rule in the training letter that we found that said that Afghanistan was part of the theater of operations in Southwest Asia wasn't actually a binding substantive rule. It was just like a heads up to their adjudicators that they would be making a substantive rule, and then they never did it, so it didn't have any binding effect. But the court was really careful in a footnote to point out to the agency that a lot of our arguments as to why the term Southwest Asia Theater of Operations should include Afghanistan were compelling, in that the Secretary should revisit that. But I heard from a very credible source, who I'm not going to name right now, but who previously worked for the higher-ups in the Veterans Benefits Administration, and who was actually privy to this whole process, that what really happened was that they really were going to amend the regulation to include Afghanistan, and then they sent it to, I think, OMB, the Office of the something about budget management, and because they're the ones who have to review every proposed regulatory amendment and determine the cost, and OMB said it was going to cost them way too much to include Afghanistan, so then they abandoned the project. So that's my intel as to what actually happened. But now we live in a world where Afghanistan is not part of Southwest Asia.
Yeah, and that's the point.
Yeah.
Persian Gulf War veteran coming out of Iraq, no. But if you're a veteran of Iraq, Persian Gulf War veteran of Afghanistan, no. So the second part of that is, did you serve in Southwest Asia after August 2nd, 1990? That's when the Persian Gulf War started, according to Congress. There's no end date, so right now, veterans serving in Iraq can qualify as Persian Gulf War veterans. That was our first requirement. Our second requirement are objective manifestations of a qualifying chronic disability. This is the complicated one. Then we have one more about the presumptive period. All right. Do you have a qualifying chronic disability? This is when people talk about Gulf War illness or Gulf War syndrome, they're talking about these qualifying chronic disabilities. And there are three possible sort of things you could be talking about. You could be talking about undiagnosed illnesses, medically unexplained chronic multi-symptom illnesses, or MUCMIs, and then certain infectious diseases which have been deemed by regulatory authority to warrant the presumption. So we'll start with the first one, the undiagnosed illnesses. What is it? This is the classic Gulf War illness. case where the veteran is suffering from a cluster of symptoms that can't fit under a known diagnosis. And so he has, well, for example, headaches, muscle pain, joint pain, fatigue, even menstrual disorders. Those are just examples. It can be literally any symptom that doesn't fit under a known diagnosis. That would be an undiagnosed illness. And you can show that you've got this with a variety of evidence. You can use the veteran statements, buddy statements, just lay statements in general. I've noticed the veteran complains about his headaches all the time and is taking inordinate amounts of ibuprofen. It could be subjective symptoms, the veteran himself saying, my legs feel like they're burning all the time, but you look at them, nothing looks wrong. Even non-medical evidence like time lost from work or even seeking treatment for the symptom can be evidence of the undiagnosed illness. And then, as you would expect, objectively perceptible medical signs. So when a doctor examines the patient and lists symptoms that are undiagnosed, there you have it. So those are the undiagnosed illnesses, the way you can prove that. You also have to prove that it's chronic, though, which essentially just means that he's been suffering from this undiagnosed illness for 6 months or more. It can be intermittent. The symptoms can come and go, but it's got to be 6 months or more, measured from the first time the veteran suffered from one of these undiagnosed illnesses. Okay, so those undiagnosed illnesses, that's one way you can show that you have a qualifying chronic disability. Another way you can show it is with a MUCMI, a medically unexplained chronic multi-symptom illness. There is a key distinction between a MUCMI and an undiagnosed illness, and that's that MUCMIs are diagnosed illnesses. So undiagnosed illness, you don't have a diagnosis. With a MUCMI, you do, but the diagnosis doesn't have a conclusive pathology or etiology. Even diagnoses like diabetes that have partially understood pathology, not MUCMI. So it's got to be completely without a known pathology. So I just bring up what I'm about to talk about, functional and structural gastrointestinal disorders, because the regulation expressly talks about them. So I'm going to as well. Functional GIDs, gastrointestinal disorders, are MUCMIs. Structural ones are not MUCMIs. So you can argue, though, any disorder of your GI tract that isn't structural is functional. Seems clear to say, but what is a functional one? What do we mean by that? You've got a group of conditions or symptoms. They're characterized by chronic, recurrent symptoms. They're unexplained. This is the key part. Unexplained by any structural, endoscopic, laboratory, or other objective signs of injury or disease. So you know something's wrong with the GI tract because it's not working right. But if you were to examine the tract, you wouldn't see anything wrong. That's a functional GI disorder. So common examples would be IBS, functional dyspepsia, so on. Try and just, again, put this in a way we can understand it and kind of grasp onto it for the sake of the presentation. Functional ones, if you were to examine the patient, you wouldn't see something wrong with the GI tract, but you know something's not working right. A structural one, if you were to examine them, you would be able to find some abnormality that might explain why it's not working right. And again, the consequence of that distinction is that a functional GI disorder is a MUCMI and a structural one is not. So a functional one will get you the presumption, structural one will not. I think this would be a good moment. So Amy practices this kind of thing.
Can I clarify one point?
Sure.
Hey, can I ask a question, Amy? I'm sorry. For VSOs out there, anyone else doing an actual discipline, do they need to specifically, when they're doing the 526, to say this is functional IBS versus, do they need to specify that in the 526?
If you think it is functional or structural, then it's helpful to point that out. But remember, even if your Persian Gulf War veteran has a structural gastrointestinal disability like GERD or what's another one?
Crohn's disease. is another
Crohn's
one.
disease, you can still, that veteran can still be service connected for that disability, either for direct service connection. All Brian's pointing out here is these are the types of gastrointestinal disabilities that you don't need a medical opinion for. But if the veteran has GERD or Crohn's disease or, diverticulitis or something like that, and you can show either through a medical opinion or lay evidence that would support a medical opinion that those symptoms began in service or are otherwise related to some exposure that the veteran had in that service, veteran's still entitled to service connection, just under the direct theory.
And clarify, stuff like Crohn's, they need a nexus because that's not a presumptive.
That's right. Okay, except that some gastrointestinal disabilities are considered chronic conditions under VA regulations, and if those disabilities have manifested to a degree of 10% or more within the first year of discharge, that's another way to get presumptive service connection for certain gastrointestinal disabilities. I'm not sure that Crohn's is one of them, but I know like peptic ulcer diseases. So that's a whole different regulation. So that's 3.3037 and 3.309. But some other kind of non-gastrointestinal disabilities that I've argued in my own practice could potentially be MUCMEs, and these arguments have prevailed, include cardiomyopathy, which is an enlargement of the heart. Now, in that case, it's probably arguable that there's a known pathophysiology because you can see on an x-ray that the heart is actually enlarged, it's not just symptoms. But the reason that I made that argument is because the examiner who looked at the veteran in that case explicitly said I don't know what's the etiology, it's idiopathic, which means no known etiology. So I argued that at least raised VA's duty to look into whether this thing is a MUCME, and I'm not really sure how that came out. I just had a case dealing with lupus, where I argued that lupus is potentially a MUCME, and the general counsel's office agreed, and even epilepsy. So long as a doctor says there's, it's idiopathic, I don't know the etiology, then you have to move to the next question is, well, is there a known pathophysiology? That's medical determination that the doctor would have to, address. But those are certain kinds of disabilities that you can argue might be a MUCME. The Federal Circuit Court of Appeals just recently came out with a decision that said in some cases, even rheumatoid arthritis might be a MUCME. In that particular veteran's case, it wasn't, because the examiner in that case was able to say, I think, what the possible etiologies were, but the Federal Circuit made clear it's a case-by-case determination. What might be a disability with a known pathophysiology and etiology in one veteran's case might not be a disability with a known pathophysiology and etiology in another veteran's case. So it's really important as advocates that you take a very close look at the claims file and the medical evidence, and if there's any question as to why this veteran has this particular disability, even though there's a diagnosis, you should be arguing that this theory of presumptive service connection is potentially available.
Yeah, so I think a good point to focus on is that it's not, don't walk away from the presentation thinking that we're just talking about gastrointestinal disorders with MUCMEs. It's literally any diagnosis that has these characteristics. As Amy was saying, rheumatoid arthritis could be one of them. So this is kind of reorient everybody on the roadmap here. We're under the second requirement the regulation, which is the qualifying chronic disability. First, you can show that through an undiagnosed illness. You can also show it through a MUCME, which we were just talking about. The third way that you can show this are through certain infectious diseases. This is the regulation that deems 9 diseases to warrant the presumption. strangely, about the infectious diseases. We just spent a lot of time talking about how Afghanistan is not part of Southwest Asia, but for purposes of these diseases, it is.
So I have a little more backstory on that. Back to Cox, the bane of my existence. In their briefing, the VA said that their authority, so the Afghanistan thing and the infectious diseases, that's not found in the statute. What happened is Congress promulgated two statutes in 1991. One, 38 USC 1117, said VA has to presume service connection for undiagnosed illnesses and MUCMIs, medically unexplained chronic multi-symptom illnesses. And then in 118, it said the VA has to continue to study these issues and the environmental hazards that people were exposed to in the theater of Southwest Asia, and promulgate new rules as the science dictates. So in their briefing in Cox, the VA said that their authority for this part of the regulation that talks about infectious diseases but only for Afghanistan was 1118. Well, what's wrong with that? Well, 1118 only gives them authority to promulgate regulations for veterans who served in the Southwest Asia Theater of Operations. So Afghanistan's not the Southwest Theater of Operations. They didn't have that authority through that statute to promulgate this part of the regulation. Now, of course, there is like the general statute that provides the Secretary with the authority to promulgate any regulation that it needs to implement the statutes. But the VA didn't rely on that. It relied specifically on 1118. So all signs point to everybody really agrees that Afghanistan is indeed part of Southwest Asia, but they defended in the court, agreed with them in Cox, and now we live in a world where Afghanistan is not part of Southwest Asia.
Except here for infectious diseases. Subsections A and B are simply the ones that talk about undiagnosed illnesses and MUCMIs. So those are still excluding Afghanistan from their definition of Southwest Asia. Subsection C here does not. These are the 9 diseases that warrant your presumption. I'm not going to try to pronounce all of them. So I'm sure that would be entertaining. All right. So we've survived the most complicated requirement of this presumption. First one, are you a Persian Gulf War veteran? Do you have objective manifestations of a chronic disability? That's the undiagnosed illness, the MUCMI, the infectious diseases. We got that. Last one's easy. Did the disability manifest during the presumptive period? Which is either active service in Southwest Asia or before December 31st, 2021. It's a date that's set by regulation, and so right now, a service member serving in Iraq could claim the presumption if he exhibited the qualifying chronic disability.
And Brian, how does one determine if a disability is manifested to a degree of 10% or more?
How do you determine if it's manifested to a degree of 10% or more? Well,
Do they look at the VA schedule for rating disabilities?
I don't know.
Yes, they do.
Do they?
Yeah.
Okay, there you go. There are a couple sort of, additional considerations, we'll call them. So you might think about undiagnosed illnesses or MUCMIs and think that if we have to show an undiagnosed illness, if a physician actually diagnoses a veteran with an illness that has known pathology or etiology, is he just entirely out of luck, can't claim the presumption? And it just depends. So if the diagnosis has a known etiology or pathology, we've got a diagnosis, so we can't use undiagnosed illness. We have known pathology and etiology, so we can't use a MUCMI. So it would look like he's just going to be out of luck. The kind of exception I'm trying to point out here is if this diagnosis accounts for symptoms 1 through 4, you can't claim the presumption for those. But the veteran still exhibits other symptoms that aren't accounted for by this diagnosis, he may claim the presumption on the basis of those symptoms. And sort of the last point I'll make about this, you might also think if we have to show he has an undiagnosed illness, do we have to go and find every test that can try and diagnose what he has, undergo every laboratory examination, so we can actually say with certainty what he has is undiagnosable? The answer to that, in short, is no. We get that from a case called Joyner versus McDonald. It was tried by a very good attorney named Amy Odom. She'll share more about
I went
that.
from excellent to very good.
I set the standard too high at first. What did I do?
Yeah, I know that. I'm done talking about Cox. So Joyner is a Federal Circuit decision, came out about 2 years ago. And the way that this case came to be is that we did have an Iraq veteran who complained of joint pain, and the VA examiner said, well, there's no pathology here, there's no diagnosis. Now, as the law currently stands, in order to prove direct service connection, so the current disability, in-service, injury or disease, and a nexus between the two, you have to have a diagnosis for number one. So just pain alone is not going to be enough under number one through the traditional route of service connection. Now, it might behoove you to know that that is currently under attack also by NVLSB, also in the Federal Circuit, and we just had oral argument last week, and the judges appear to be very open to our argument that that's not the correct standard. But for our purposes right now, let's just operate based on what is the current state of the law, which is that you have to have a current diagnosis in order to achieve service connection through the traditional three-step analysis. Now, that's, of course, not true when you're talking about Persian Gulf War veterans, because the whole purpose of this presumption is that there's oftentimes not an explanation for these symptoms. But in Joyner, the Veterans Court, in a single judge decision, we argue that the Board of Veterans Appeals made a legal error by not considering the Persian Gulf War presumptions in this veteran's case, and that the duty to do so was triggered once that examiner said that there was no pathology or diagnosis for the joint pain. And in a single judge decision, the Veterans Court disagreed and cited that rule that's now currently under attack, that you have to have a diagnosis in order to have a disability for VA purposes. So, I mean, we couldn't have gotten a better decision to take up to the Federal Circuit. Took it up to the Federal Circuit, and VA defended this single judge decision by arguing that what the single judge really meant was that in order to prove that you have a qualifying disability for VA presumptive service connection purposes, the doctor has to diagnose undiagnosed illness. So the doctor has to list as a diagnosis undiagnosed illness. I mean, come on, right? And that's essentially how the bench reacted to that argument. And in Joyner, the Federal Circuit said, no, that's not right. You're talking about 1110, and even assuming it's true that, and by the way, 1110 is the traditional service connection statute, and even assuming that that's true for the traditional service connection route, it's clearly not true for presumptive service connection for Gulf War veterans, because Congress specifically said it's got to be something that's not attributable to a known clinical diagnosis. Oh, and by the way, it's unreasonable to expect a doctor to put this veteran through every single conceivable test in order to rule out any possible diagnosis. It's enough for the doctor to say, I've examined the veteran, I can't find any pathology for the complaints, there's no known diagnosis.
Thanks. Okay, so those are the requirements for claiming the presumption. Those are some additional considerations about it. We're about to take a hard pivot here, a transition, kind of out of talking about how you claim this presumption and talk about some other areas you want to be dialed in on if you're going to represent veterans coming out of the Persian Gulf. So, you know, a lot of other common problems we see in these veterans are going to be TBI, respiratory problems from burn pits, which we'll talk about later in the symposium, heart and lung problems from dust storms in the environment, and then PTS, the hallmark injury of OIF and OEF. And so to talk about PTS, we're going to pass it back to Alec, and he'll get you dialed in on that.
Thank you. So for PTS, first it's important that we define what is PTS. I'm sure everybody here has heard of it and is familiar, but let's lock in the actual definition. It is the development of characteristic symptoms following exposure to one or more traumatic events. And the symptoms can include, but are not limited to, guilt about surviving when others did not, anxiety, nervousness, depression, nightmares, flashbacks, jumpiness, just to name a few, but the list goes on and on. Now, why is this so important? And it's because PTS is incredibly prevalent in all veterans, regardless of where you served. For instance, PTS is extremely frequent in Vietnam veterans. 30% of Vietnam veterans will suffer from PTS in their lifetime. And in addition to that, it, like Brian just pointed out, it is one of the hallmark injuries of OIF and OEF veterans, and it occurs in 11 to 20% in any given year. And I think it's also really important to point out that these statistics are underreported. So in actuality, the people suffering from PTS is a lot larger. The number of people is a lot larger than these statistics kind of insinuate, despite these percentages still being a large amount of people. Now, we've kind of talked about the requirements of your traditional disability benefits claim, the special rules for the presumption for Persian Gulf War veterans, and now we'll talk about some of the actual requirements for PTS, which on their face look to be essentially the same as your standard disability claim, but there are some small differences, and we'll kind of touch on those in a general sense. So first, you have to have your current diagnosis of PTS, and this kind of comes back to the importance of, at the beginning when I was talking about evidence from individuals who have specialized training. So you don't have to go see a medical doctor for this. You could see psychiatrists, psychologists, one of those is a medical doctor, and then a social worker, and any of those people who have that training can say you suffer from these symptoms, and it appears as though you're suffering from post-traumatic stress. Now, in addition to that, you're going to have the other two requirements where you have to have the evidence that the in-service stressor occurred, and that you have that nexus requirement connecting that in-service stressor to your current symptoms of PTSD. But something important to point out that's special to PTS, should refrain, go back, PTS, is that the requirement for the in-service actually occurring is a little bit stricter than your standard disability claim. And that's just something to keep in mind as you advocate for veterans who do suffer from post-traumatic stress. Now, for that requirement, the credible supporting evidence that the claimed in-service stressor actually occurred, there are some exceptions where you don't necessarily need credible supporting evidence, but one of these characteristics acts as that credible supporting evidence. So for instance, fear of hostile military and terrorist activity. If you're somewhere where there's a lot of mortar attacks, but you're not necessarily in combat, you're not going to have to provide additional credible evidence. The fact that you were in that area and they were subjected to mortar attacks is going to be the credible evidence to support that there was in fact an in-service stressor. And the same goes for...
It's actually, that's right. So as long as, your statements alone about what happened to you in service are related to fear of hostile military or terrorist action and are consistent with the types, places, and circumstances of your service, that'll be alone enough if you also have, a VA doctor who says that stressor caused the PTSD. And it has to be a VA doctor. It can't be your private treating psychiatrist. So it's actually the VA doctor's opinion that there's a nexus between the fear of hostile military and terrorist forces and your current PTSD, that is the credible supporting evidence in that particular circumstances. So it's just a little tiny bit nuanced, but the major takeaway is that VA has determined that only VA examiners are competent to make that link and provide that credible supporting evidence.
Right, and that's definitely an important caveat to point out. And in terms of the other few down here, it applies in the exact same manner. If you had an in-service diagnosis, obviously if you were diagnosed with PTS during service, that is going to be enough to say that you did suffer from PTS in service. You incurred it during service. That's pretty straightforward. And it's sort of the same approach for the POW or the personal assault as it was for the two at the top with fear of hostile military, veteran engaged in combat. That's going to act as that credible supporting evidence. So I know we just barely touched on PTS, but it's definitely important to put in there because if you're advocating for a veteran with these high statistics, there's a good chance that they might be suffering from that, and that's important to note and know how to deal with that when it comes up. So just to sort of summarize what we've gone through here, we've talked about the standard disability benefits claim, where you need a current disability, evidence of an in-service injury or aggravation, and then the nexus linking the two. In addition, we talked about the Gulf War presumption claim, where the nexus requirement disappears and the causal link is presumed if you were a Persian Gulf War veteran, if you have that qualifying chronic disability, and it manifested during active service, or 10% within a year of your return. And last, just to kind of go over what I just said in the PTS, you have the current diagnosis, evidence that the claimed in-service stressor actually occurred, and we had those 5 exceptions where the burden, the evidentiary burden is lessened. And then finally, you have that nexus of connecting that in-service stressor to that actual symptoms of PTS that you have. And that sort of concludes our presentation. So thank you very much for sitting through that, and if you have any questions, feel free to ask.
And I do want to clarify, later in the afternoon, we'll also have more on PTSD and the proper review of it. But as Alex said, we can open the floor right now for any questions on this topic.
I guess more of a comment than a question. So I recently received a rating. I'm a Gulf War veteran, and it was an item that's very difficult to prove medically. And there, if you're looking for someplace and you have a Gulf War veteran as a client, you're looking for somewhere to get a very advanced medical examination. There are a ton of DOD-approved medical studies that are going on around the country. Boston University, Harvard, University of California, San Diego, and they are begging to have clients people come in as a patient, and then what I was able to do was going into one of those examinations, I was able to say, and there's a lot of times the funding's not traveled, so it's very difficult to get people to participate. I was able to say, listen, I'll be glad to participate, but if you find anything, I'd like to have something written up because it's specific to me, and I was able to use that and then submit that as part of my case profile. So that's an option if you're trying to get some additional evidence for potential clients.
Yeah, I think that's a really great point, because something to keep in mind if you have one of these cases is that there was a recent, I think it was either a VA Inspector General report or a GAO report that found that the denial rate for these types of claims is very, very high. And that can be explained simply by it's a really complicated issue. The statutes and regulations are really, really complicated, and perhaps VA needs a little more training for their adjudicators on this issue. And also, if you have the right evidence, this should be a really easy claim to win, right? Because all you have to have is your veteran saying, my joints hurt, and have some lay evidence that supports that, and have a doctor saying there's no arthritis or tendinitis or anything else. So that makes it a really easy claim to be able to prove. And sometimes, just VA doesn't really like those types of claims because they're very protective of the public purse in some instances, which is, part of their job. And I'm saying that because I know we have VA here. But this is a really complicated area, and that VA really truly hasn't even fully worked out how to apply their own rules and regulations, as we saw from the Joyner case, where VA argued that in order to win under these statutes and regulations, the veteran has to have a diagnosis of undiagnosed illness, which is just preposterous. So that's a really good point, that going out and getting your own medical evidence to prove these cases is very helpful, because in a lot of cases, even the VA examiners that veterans are sent to don't have a real grasp on what they're really supposed to be looking for.
What about this business of it had to manifest itself during your active service or the first year after? I know a lot of vets like me. I mean, I was back as a civilian 3 months after we got back from the Gulf War, and I wanted nothing to do with military health care. And, you know, I didn't come into the VA system until the Affordable Care Act, wasn't affordable. And, you know, I guess what I'm trying to say is there's a presumption that you trust your bodies. And has that been attacked?
Well, so first I just want to make a small correction. The rule is first manifested in theater or to a degree of 10% before 2021. So for Persian Gulf veterans, it's not true that it has to manifest within the first year. Now, if we're talking about one of these diagnosed chronic diseases, those have to manifest in the first year. And that makes sense, right? Because if we want the law to presume, right, so remember, we're talking about presumptions. We don't need a medical doctor to say that something's related to service. If we want the law to presume that a chronic disability like arthritis or something was incurred in service when there's no evidence, medical evidence of a diagnosis or symptoms in service, it kind of makes sense that we want that the symptoms to have at least started within the year of service. So that's the first point. And the second point is, it's true that a lot of people don't seek medical care for every little joint ache or headache or something like that that could qualify under the rules as a undiagnosed illness. And what's really important to take away from that is that lay evidence, right? So just statements from yourself, from family, from friends who have personal knowledge of you complaining of these symptoms is enough, because the law recognizes that, again, not everybody goes to the doctor every time you have a headache or a joint ache. So as advocates, it's really important to counsel your clients and to work with your clients in developing that lay evidence, which can be a really powerful tool, evidentiary tool in these cases.
My name is Gary Noel, and I'd like to add a few remarks. I'm a Vietnam veteran, and I got back from Vietnam in 1968. And we absolutely wanted nothing to do with military or military doctors in the VA. You know, we went about our lives. The public perception is not friendly to Vietnam veterans at that time. So I just wanted to.
Well, thank you for your service.
I just wanted to ask you, you said that I guess the PCS has to have a nominated VA doctor.
So only okay. So what Alec was hitting at is that for most claims, you don't have to show in your service records that what you're saying happened to you in service happened. Lay evidence, statements can be enough in most situations, in many situations, I should say. The only regulatory exception to that rule is with PTSD, where the regulation specifically requires credible supporting evidence of your in-service stressor. So what Alec was saying is that that's a higher burden than in most claims, but recently VA has reduced that burden for veterans who are able to, who say that their stressor was something that was related to hostile military or terrorist forces, and the VA examiner says that that's enough to support the diagnosis of PTSD. So say your in-service stressor is a car accident, which is, by the way, a very common cause of PTSD. And it had nothing to do with hostile military or terrorist forces. It had nothing to do with combat. You weren't diagnosed in service, and it had nothing to do with personal assault. In that case, your private your private psychiatrist can provide an opinion for you and say that the car accident caused the PTSD that you now currently suffer, but you have to be able to prove by not just your own statements, but by credible supporting evidence, which will usually have to be something in your service records or some hospital records or something that you were actually involved in this car accident. Your statement alone won't be enough.
Now, when the PTSD is a secondary effect, say, like sexual trauma, how would you go about proving that the person didn't report it, or perchance man were the perpetrators?
Yeah, that's a really good question, because as we know from common sense and now from the attention that's been given to the subject, is that the vast majority of military sexual trauma goes unreported. And VA has tried to deal with that by creating another reduced evidentiary standard for claims, PTSD claims based on personal assault is what they call it. So it encompasses more than just military sexual trauma. But in those cases, you don't have to have the attack actually documented in your service records, because it's not going to be. And it's probably not going to be documented in any criminal records or anything like that, because it's not reported. So instead, what VA will look for is evidence of behavioral changes. So drug use, transfer orders, a decline in performance. Other evidence could be if the veteran confided in a family member or a friend, that person's statement today that this is what the veteran told me 27 years ago will be evidence. And you know what else is evidence? Any doctor saying that this person's symptoms of PTSD are consistent with a victim of sexual assault. So there are other ways to go about that. Now, historically, VA has had a poor record with PTSD MST claims. The ACLU actually did a study several years ago that showed that PTSD claims based on MST were denied at rates that were much, much lower than PTSD claims based on other types of stressors. And since then, VA has really been making a heroic effort, and I say that not just because I know VA people are here, but VA has really been making a great effort at training their folks and doing more quality review. And I got to tell you just anecdotally that I see way fewer MST cases come up through the board to the court than I did even 5 years ago. So they've been really doing a much better job in adjudicating those claims. And it's important to remember too that if your veteran doesn't have PTSD but has something like depression or an anxiety disorder that's related to an MST or a sexual assault in service, you don't need that credible supporting evidence, right? Because the regulation says you only need it for PTSD. Now, is the regional office going to buy that argument? No. But, I mean, legally, that's what the regulations say. You only need the credible supporting evidence if it's PTSD. If it's any other kind of mental disability, the statements alone should be enough legally, especially since there's now case law out there that says that you can't use the fact that there's no documentation of a sexual assault in somebody's service records as negative evidence because of the fact that these things go unreported so much. But that's something really that you'd have to argue to the board or to the court, because the regional offices I don't think would be able to decide a claim that way. That's right. What Professor Drake just said is military sexual trauma isn't just limited to women, that men also are victims or survivors of military sexual trauma.
In defining Persian Gulf veterans, is that limited to those who were actually deployed to that region, or could that include support troops who got deployed?
Brian, do you want to answer that question and tell this gentleman what are the geographical areas that the veteran had to have served in?
So there's the regulations 3317 sub E2 that defines the exact countries we're talking about. So it is a specific geographical region they have to be in. I can list them for you if you like.
Okay.
You've answered my question.
And the airspace above these countries also counts. So even, unlike those of you who are familiar with the Agent Orange presumption with Vietnam, you have to have boots on ground, right? That's the rule. Boots on ground, blah, blah, blah. But for Gulf War veterans, the airspace counts.
Are there any other questions before we wrap it up? Go ahead.
So we spoken a lot about how the doctor needs to say, and the doctor needs to show a nexus with the report or whatever it may be. The doctor needs to show that it's related to service. But really there has to be quite a bit more than that, right? The doctor needs to describe why they feel that way.
Right, so.
And in that case, would a DEQ be a perfect tool to use for the doctor to clarify why they feel that that condition is related to service?
So long as the doctor provides, so for those of you who don't know, a DBQ is a disability benefits questionnaire, which is basically a form that VA provides to veterans to bring to their own doctors for VA medical exam purposes for certain claims. So you can't, for an initial PTSD claim, the VA won't accept a PTSD. For Gulf War claims, or DBQ, for Gulf War claims, they won't accept a DBQ. And then I think TBI and hearing loss are two others. And so it's basically like the doctor just checks some boxes. So it's really helpful if you're already service connected and you're trying to get a higher rating for, like, say, like a knee injury or something, because all the doctor has to do is check a box saying where your range of motion ends, whether you have pain, whether you have other symptoms that might get you a higher rating. But what this gentleman has pointed out is, are those helpful when you actually need the nexus opinion? So you need a nexus opinion from a doctor linking your current disability to something that happened in service. And the answer is sure, why not, right? There's usually a few lines at the end that are blank that say something like notes or other comments, and just have the doctor write out there. It's at least as likely as not, or better yet, more likely than not, that this veteran's knee disability is related to the in-service knee injury, and I've reviewed the service records and have seen the in-service knee injury. That's important, that the examiner has a complete factual basis and notes that the examiner had the complete factual basis upon which to base the opinion, and provides a rationale. Why does the doctor think that it's at least likely as not, or better yet, more likely than not, that the in-service knee injury caused the current knee disability? And it could be because what I'm seeing on an x-ray is consistent with old trauma or something like that. But VA is generally going to reject the opinion as not probative and go out and get its own opinion if there's not some sort of explanation from the doctor as to why the doctor or other medical expert believes that there's a relationship between the in-service injury and the current disability.
If there's no other questions, I think we'll wrap up this topic unless the panelists have anything else to add.